Our moderator, Onyekachi, you can unmute yourself and start now.
I'm on a call. Hello.
Okay.
Yeah, good evening.
Hello.
Hello,
Good
hello, we
evening.
can hear
Good
you.
evening, everyone.
Good evening.
I bet I'm audible, right? So
Yes.
I've gone through today's the slides from the mentees, and from the topic I can tell the creators we're looking at is strictly based on copyright, based on what I've seen from the writer. So first I want to appreciate the team
Excuse me,
for putting up.
sorry to interrupt.
Can you hear me? Yes?
Yes, I'm sorry to interrupt.
Yes, sure.
I'm trying to introduce the moderator for today's session to start moderating, but I don't think she's on the call yet.
Oh, I see.
Okay, she's on the call. I can see her. But please, I'm sorry. You'll be given the floor to talk when it's time. I'm sorry.
All right, perfect.
Okay, thank you very much.
Now.
So I can see Ogona Aneta is on the call. Ogona.
Yes.
You are just silent. I don't know what's going on.
I just joined, so I don't know. Are we supposed to be doing something?
Hello everyone.
Ogona Aneta.
Guys, I'm having network issues. Please confirm if you can hear me.
Oh, sorry, wrong Ogona. Sorry.
All right, and we can hear you. Thank you very much.
Hello, please confirm if you can hear me.
Yes, we can hear you now.
All right. I am Ogonna Annette Onwudiegu, a founder-level law student in Nnamdi Azikiwe University and an IP enthusiast. I'll be your moderator for this session. I'm thrilled to introduce everyone, to meet everyone, all our participants. Welcome to the third quarter of the Jiipcc Intellectual Property Program. And this program is aimed, this program is aimed towards students and young professionals across Africa, affording them the opportunity to access valuable advice, training, network, different mentorship sessions and discussion forums and as access to experienced mentors. So it encourages continuous training, development, and evolution in Africa and around the world. So if you want to gain access to videos and different content on Jiipcc, YouTube, and Facebook, just have to put on the hashtag JIPC MIP. So what is the objective of this program? So the Jiipcc mentorship and internship program is aimed at providing easy access to quality professional guidance, training and resource materials for students and young professionals in Africa. So it also aims at facilitating dialogue and network among experienced and less experienced practitioners and stakeholders. It aims at transforming mentees into mentors, leaders for the next generation. And finally, to facilitate further mentorship, internship, and scholarship and job placement for the mentees. So this is Jiipcc's way of contributing to the world quota on intellectual property. So it's a way of contributing to the world's big plan and raising professionals that would bridge the data gap in Africa. And aside intellectual property, we also have other programs that our mentees can benefit from. We have the artificial intelligence and technology, we have the energy industry, we have fintech industries, health tech and law, we have patent drafting, blockchain, NFT and metaverse, data privacy and protection, entertainment business and law. And these these are online courses which are available upon registration. So the registration program is still ongoing. I particularly am a beneficiary of Jiipcc intellectual property training, and I would advise everyone here not to hesitate. Aside that, we also offer 30-minute one-on-one mentorship with any mentor of your choice, your favorite Jiipcc mentor. You just have to reach out and indicate your intent. I'm going to be reading out our mentor's profile. Our mentor, Mrs. Onyekachi Ngozi, is graduated with honors from Olabisi Onabanjo University, OOU. I was called to the Nigerian bar 14 years ago. She served with the Legal Aid Council, Osun State chapter, where she initiated and anchored a TV program on law awareness, You and Law, via which she educated the citizenry on their rights and how to access legal aid services in Nigeria. Through this initiative, among other works, the Osun State Government Honors Award was bestowed on her. She worked briefly in the private sector as a company legal assistant in a media outfit. She also joined the Civil Service of Nigeria in 2014 and is currently a senior assistant registrar in the Commercial Law Department of the Federal Ministry of Industry, Trade and Investment, where she served in various capacities, secretary to the Board of Service, FMITI. She's a beneficiary of the World Intellectual Property Organization sponsored master's program and just recently concluded the Harvard Copyright X program on scholarship. She's passionate about intellectual property and its growth in Nigeria and believes in an IP-enabled and engineered civil service in Nigeria. She's currently one of the innovation think tanks and feature leaders in the Federal Civil Service through the Innovation Challenge and the Leadership Enhancement and Development Programs, LEAD-P, of the Office of the Head of the Civil Service of the Federation, through which she is deployed to make input in strategic government offices. She's a peace advocate and holds qualification in peace and conflict studies from the Institute of Peace and Conflict Resolution and a master's from the Nigerian Open University of Nigeria. She's a member of the Institute Chartered Mediators and Conciliators, ICMC. As a peace advocate and a passionate intellectual property professional, she stupendously combines both skills in creating awareness for startups and talented Nigerians on social media, in the legal space, and in government. The results have seen businesses avert infringing acts, collaborate and settle their disputes amicably and administratively. It has also earned the titles such as LEAD-P Future Leader, a Federal Civil Service Innovator, an African Peace Awardee 2021, and a nominee for the 2021 ESQ Under 40 Nigerian Legal Awards. That is for our mentor, Ms. Onyekachi Ngozi. It's a pleasure to have you here, ma'am. Our second mentor is Ms. Amosa Shukurat. I hope I got the pronunciation right. She's a proficient consultant, analyst, and educator in the field of intellectual property with public sector experience. She's a member of the World Intellectual Property Organization, WIPO committee, and has a master's degree in intellectual property at African University, Zimbabwe, in conjunction with WIPO and the Japan government. She has partaken in professional training at the World Intellectual Property Organization, as well as other IP-related bodies, and has facilitated numerous IP-related programs both online and offline. She's a pioneer of an educational platform, DIN, the Intangible Nugget, which facilitates IP awareness and brings the knowledge of IP closer to everyone. In celebration of the 2022 World IP Day, she partnered with other stakeholders to sponsor 5 IP enthusiasts and register them for WIPO advanced courses. AMOSA is an accredited agent at the Nigerian Intellectual Property Offices, which includes Nigerian Copyright Commission, Trademark, Patent and Design Registry. And our expertise are, but are not limited to trademark, patents, industrial design, copyright, and trade secrets, respectively. We welcome our mentors to this session, and we wish to tell you that we look forward to drinking from your well of wisdom. We look forward to this mentorship session and sharing your knowledge with us. Please, you have the floor.
Okay, quickly, our moderator, I want to chip in something. We'll be receiving Miss Amosa on the call a bit late. She just informed me that she'll be joining a bit late. She's at her kid's graduation, so we'll be taking Miss Onyekachi's input, overview on the topic for today. As we all know, the topic for today is intellectual property for creatives and inventors. And we're taking an introduction to the topic. And if Miss Amosa is not on the call when she's done, we will be taking our mentee's presentation also. And we hope that after our mentee's presentation, Miss Amosa will be joining us. So Ms. Onyekachi, kindly note that you have the floor for 45 minutes max. Thank you very much.
Thank you, hello everyone. Thank you for the introduction. I like to have that my profile long improved a long time ago. I think the profile you read out, you've had it for like 2 or 3 years now, perhaps. All right, that being said, so I move forward to my presentation. So the title assigned to me, Intellectual Property for Creators and Inventors. So these are basically what I'm going to be touching on. I hope you can all see my slide.
Yes, we can, ma'am.
Yes, ma'am, we can see your
basically this is what we'll be discussing. What is intellectual property? What are the journeys of intellectual property? How inventors, creators get protection? What kinds of rights do they enjoy? Understanding the rights of a creator or an inventor. And I was able to pull out these points based on the slides that I received from the mentees. I felt there were some missing gaps. And so I prepared my slide to kind of fill out what I felt were missing, because my understanding of the topic is the creators and inventors. What kind of protection do they get from intellectual property? What kind of things do they do that qualify for intellectual property protection and what have you? So it felt like some points were missing, especially on industrial design. And I tried to create a balance using my own slides. So I'll be talking much on what the mentees have already put out in their slides. So before I move forward, I want to mention that I enjoyed reading your slides. I think you guys did your homework, analyzing a couple of things that has to do with the inventors and then the creators. What kind of rights do they get? The kind of industries basically they operate in and stuff like that, and what kind of things they generate to qualify for intellectual property protection. So going forward, what is intellectual property? And my class is going to be interactive. I hope you all agree. So I'm going to be asking the mentees to please rename themselves. In front of your name, kindly add creator, or if you're an inventor, if you're under inventor, add inventor. So I'm able to say, okay, answer my question. I hope that is allowed. Is that fine?
Yes, ma'am. It's allowed.
So please, all right, thank you. So please, let's just rename and add either mentee or mentor, either inventor or creator in front of our names. Thank you. So here, what is intellectual property? Basically, I'm trying to say here that it has to do with, creation of the mind. You can perceive it as one. It has to do with properties of the mind, what you're able to conceive in your heart. It does not protect idea, basically. That's when we want to talk about copyright, or the expression of an idea. It's the creativity from the inside of you. Some people might want to relate it to intangible assets. However, there's a wide difference between intellectual property and an intangible assets. So just like a normal property, you have some right attached to your property, be it land, whatever it is, your car, whatever it is you own. The same thing happens with intellectual property. So that is what intellectual property basically protects. Those creativities of your mind, it helps you to capture them in a medium, whether copyright, whether as trademarks, whether as patents, or whether as industrial designs. So this is why we have this here. So basically the genres of intellectual property we have, the types, they are broadly divided into two. Intellectual property. You have copyright, and some will say copyright related rights. And this is in Nigeria under the office of the Copyright Commission. Then we also have industrial property. Industrial property is further divided into two, broadly divided into two. The first is trademark, and is currently under the Trademark Registry, Commercial Law Department, FMITI. Then second, we have patents and design. So the reason why there's a question mark in the middle, this is one of the gaps I saw in the mentee slides, and I'm really going to dwell on this. So we have patents and designs, and it's under Patent and Designs Registry, FMIT as well, which is my office anyway. So in the middle, there is another right that I expected to have been here. I think I mentioned it already, but if we don't mind, can I have one of the inventors just remind me what I said a couple of minutes ago? So what should we have here? I'd like to type it in. You can unmute and speak.
Yes, ma'am.
Sorry?
Trade secrets.
Trade secrets. Okay. Can we have another inventor?
Industrial design.
Yes, we should have industrial design here. So this is how we'll flow today, industrial designs. Okay, let me quickly say something. That's why I said on mute. Let me hear you. I want to know what's going on in your mind, because sometimes these topics, we can't finish it under the minutes we're given. So I'll quickly talk on trade secrets. Trade secret, ideally, people say it's not a genre of intellectual property, but however, we know it helps to protect intellectual property, hence why it is not mentioned here. So what does trade secret do for you? It helps to protect confidential information, information that is not out there, that is not easily concealed by other persons. It's like you telling a friend a secret, and then it's just between you and the friend. So when it comes to commercial business or a business sector, then you begin to talk about trade secrets. This can be maybe the list of customers, the ideas or whatever it is the company is into. Maybe it's a tech company, their codes and stuff like that. You can choose to keep them secret from other people. But there is more to that. And I have a couple of articles on trade secrets. You might just Google my name and find some of them either on LinkedIn or other journals where they've been published to learn more on trade secrets. So this is industrial designs. So beyond patents, we have industrial design. So we'll flow from here now. Essentials of a trademark, because I notice sometimes in your slides, rather than make mention of industrial designs, you people made a mention of trademarks, to use trademark to protect I think example of what I saw was in the communication industry. I think they mentioned something about trademark, which is cool. Trademark can also be used to protect the name of the mark or their logo or their slogan, whatever it is they are using. But beyond that, for instance, when it comes to the fashion industry, I was really hungry to see somebody mention industrial design, but that was also missing. So when we get to industrial design, we begin to understand what industrial design would cover for a creator and what an inventor can also get from industrial design. So quickly, trademark, ideally the essentials of it must be distinct, must not be deceptive, must not be generic, must not be scandalous, and it must be available. You know, we use the 45 needs classification. that is managed by the World Intellectual Property Organization. So why are all these essential things important? These are just the reason to avoid us having confusingly similar marks. So, because once you have a confusingly similar mark, what does that mean? It's going to be a ground for opposition, invalidation, objection, whatever category, depending on the jurisdiction or depending on the registry. If it's trademark, you begin to hear of opposition panels. If it is maybe patent, you can be hearing of maybe more of invalidation of the patent that is already granted and stuff like that. The objection can fall under the two categories. This is basically by the examiner. So who does that? The examiner objects, registrar can oppose, and other people through the trademark journal can also oppose. So it goes beyond that. So for lack of distinctiveness, that is why people want to oppose your trademark. So for a creator who creates something, whether it's a car, which is supposed to be maybe an element of patent or a little bit of copyright because it's going to have the manual or a technology or whatever it is, it will normally come with a manual. So that manual is protected under copyright. But beyond that, you also find element for trademark. So these are some of the things to bear in mind when you consider protection under trademark for a creator. Now, what should a creator and inventor have in mind? They should always apply due diligence in carving out names for trademarks. You should do search in company registry, which is our CAC in Nigeria, the trademark registry. You should consider the first use common law countries, which Nigeria is part of. The market survey should be done, domain name registry. You want to search all these areas to make sure the name is not already taken on the slogan or whatever it is you want to use, especially if you want to build a strong brand. So all this should be put in place. Now, talking about branding, branding essentially is a combination of mostly trademarks. And then on the other part, it also has to do with industrial designs. This is why I feel industrial design is really important. But I wanted to just give you an highlight on trademark. This is basically what trademark is all about, so that we're able to differentiate between industrial designs, trademarks, and patents, because there's always that meeting point. There's always that confusion somewhere in the middle. So this is why it's always been omitted. I think the last time I came on board as well, I noticed this the same problem. So what is an industrial design? It's a combination of lines, colors, or both. It's a three-dimensional shape like Coca-Cola bottle, okay? Even though Coca-Cola bottle is also registered as a trademark. It is the aesthetic quality of a product. Basically, that's what it is. It is a beautifier other than its technical results. When we talk about technical results, this takes us to patents. For those of you who are inventors, a lot of what you discussed had to do with technicalities or technical results, such as maybe a product that has to, maybe a moving vehicle, the engines in the vehicle and stuff like that, how they came about it. However, imagine a vehicle as we are speaking, the outer element of a vehicle, which is what distinguishes a particular brand from the other, not just in terms of the color, but in terms of the shape of the car, whether it's a Jeep or whatever. Just try to imagine two different Jeep brands, the characteristics, the difference between the shape of one from the other. That is industrial design. So I hope it helps us to understand next time. So when you talk about creators' right, trademark will always be mentioned, industrial designs will always be mentioned, patent will always be mentioned, and of course, copyright sometimes. So we move forward to talk about design classification, like trademark that uses the 45 NIST classification, international NIST classification. Under design classification, we have textile designs and non-textile design, like the group that discusses on fashion industry. I think it was the creators. You made mention of fashion industry, but you omitted this. You can't discuss fashion industry without talking about the industrial designs. This is basically where they get protection. Trademark at best protects the name of the brand, but what protects the creativity or the design they come up with that is on the market, or what makes their design peculiar and different from other brands' design is industrial design, because if they don't protect here, then their design is definitely at risk, especially when they go down the wrong way, then it's taken and there's nothing you can do about it. So this is very important for creators on the industrial design. And by the way, the Act also calls them creators. So when I saw the topic, I wasn't too sure if you were discussing creators as per copyright or creators as per industrial design because of the overlap in the two. So for instance, you have people, all those artists that are into maybe sculpturing and stuff like that. You find out that it's made with hand. So sometimes what they come up with, there's that confusion. Should we protect it under copyright? Should it be under industrial designs? So one of the ways we're able to differentiate between the two is the fact that industrial design is made in industrial quantity. So usually there's a machine that is put in place, like a mold, that replicates the designs, unlike what you see under copyright. Copyright is usually the artist sits down and molds that particular thing, or creates maybe an artwork, maybe 1 or 2, 3 IS copies, and that's just that. But industrial design, there's a technology, or there's a machine, or there's a tool that replicates it for purpose of selling same to a particular industry. So it's produced in mass as against them copyright. So that's one of the major difference in the two. So we have textile designs. It can be a finished cloth. It can also be just a fabric. So those are the classification. Like the non-textile, this can be a wrapper design. It can be a carton design. It can be the shape of a product. It can be the color thereof, and so many other things. Those are things that will come under. So the creators and inventors on board, could you please identify this design based on what you just learned now? You can please unmute. Let me talk to the creators now. Creators, please identify the designs. You can tell me A, what you think A is, what is B, what is C?
Okay. Hello.
Yes, we can hear you.
Yeah, I think B is an industrial design.
Yes, all are industrial design. So please identify them based on the classification that we just learned now.
Okay.
You can have another creator bail you out, anyone?
Hello.
Because of time, yes.
Okay. I think A is a textile design.
Sure. B?
B is non-textile.
B is non-textile.
Yeah.
C, textile also. Cover the
Sure.
dress.
Yeah.
And then D, I would say textile because of the let's say the mold the carton is. Oh, okay. I'm not so sure of D. What else say? I'm not
No,
sure of D.
it's good to hear from you. Any other person want to try on D? Creators?
D.
Sorry? There's a confusion on D. Let's discuss it. Another creator. What do you think?
Okay. Can you hear me?
Now I can.
Okay. On D, I would say it is non-textile because it's a product that is consumable. Though the design is, though it has a pack or whatever, but it's non-textile. But I believe textile, when they mean, what you mean by textile are things like maybe a carton or a fabric, if I'm not.
Yeah, you're very close. Thank you so much. Thank you. Thank you so much. So when we talk about textile, it's basically clothing. Like, you know, those are Ashwebi, different tribes they use for their meetings. Those are textile designs. And then finished product, like this design, this character is wearing here, or like this outfit, school uniform, what have you. Those are all textile designs. So you find schools come to the industry, to the registry to register their school uniform. That's where another school doesn't take up exactly the same thing that they have. So this is called a wrapper design. It's like a textile design, but of course it's not. It's non-textile, but we call it wrapper design because this is like a wrap. It's what's wrapping the Indomie, you know. So it's named wrapper design under non-textile. That's where you get a registration. Now, this industrial design does not last in perpetuity like trademark. Maybe I forgot to mention that. Trademark lasts like forever based on renewal. The first time for 14 years, subsequently 7 years, you keep renewing. But when it comes to the term of a industrial design, total you have 15 years. From the date of application, you get 5 years. Then from your first renewal, which is from the due date of the first application, of course. You get your first renewal, it lasts for 5 years, and then the second renewal, it lasts for another 5 years. So I have a question. What do you think happens when they write my 15 years is completed? What do you think happens to a product? Can I talk to the inventors? Inventors, what happens when my 15 years expires?
Okay, can you hear me?
Yeah, sure.
I think some other company is allowed to use that pattern. Like
Okay. All right, you're not far from the truth. However, what we see in practice is this, like Indomie. Don't you think it's long expired, apart from they have a trademark? Don't you think Indomie product is long expired, the wraps? So using Indomie as example, have Indomie at the back of your mind. So can somebody react to that? Still inventors? What do you think happens with Indomie when it expires? What about the wrap? Why are they still in the market?
I think it's nobody's changed their wrap.
Sorry?
I think like for Indomie,
Yes.
I'm a fan of Indomie.
Sure.
Sometimes they change the, will I say the wrapper? Either they had one new design to it, or they put that their Fantastic Five on it in a different.
Excellent. Thank you. You've been the one talking. Are you a creator? I was talking to inventors. Are they not here? Thank you for that.
I'm sorry, I didn't know where.
Okay, it's fine. But that was an excellent response. So that's what happens. It's not all the time a product expires or falls into the public domain. Nobody wants to create something and somebody takes it over after 15 years. So what do you do? Because most of us perhaps we're lawyers, or we're about to be called to the bar, or we're still law students, or tomorrow we're going to have clients who are SMEs. We should know how to advise them. So this is why I'm throwing it open. So we have some interaction where I think you make a mistake, I correct, and what have you. So I think it's going to help us better to know how to address challenges we meet in the field, rather than just talking straight to the slides. So that's exactly what happens. They kind of review or just adjust a little bit of the logo or their designs and whatever, and they keep flying in the market. So that's what happens. And it starts all over. It comes in as a fresh application, it runs for another 15 years, and then they do the same thing. So that's why I see products, they say, the same taste, just that they change the pack. You know, you see adverts to let people know what they have done newly and what have you. Now, back to our main topic. Now that we have a good understanding that creators and inventors can also benefit from patterns and industrial design, because there is an overlap in all of it, especially with patterns and industrial design. Let me take that part again. For patterns, for instance, it takes care of the technology in a product. Maybe imagine a fan. We all have a fan wherever we are, except on the road, or even an air conditioner. The technology that makes the fan to work, for the blades to rotate, and then it's blowing and keeping the room cool, that technology is protected under patents. However, the body shape of the 2 or 3 fans in your house, you notice they're not the same design, perhaps. So the difference in those designs are protected under industrial design. They take care of just the aesthetic qualities. That's the outer effect of a product. Do you understand? It doesn't take care of the technicality or the technology inside of the product. So it's limited just to the outer parts, which can include the colors, the shape of the fan. Sometimes the logo is also protected under industrial design, depending on what the company wants and who is advising what. So for us to talk on this part, I'm going to quickly take us to a slide. We're going to be working on this together. I'll take you all to my Google Doc. I hope you can see this. So we're filling this together. I've read your slides and I think you did a good job. So I want to talk to the creators first. What can you tell me about the topic today? Intellectual property for creators and inventors, limited to creators. What can the creators, I believe you all did a teamwork, not that somebody's just in the team and didn't participate. I don't want to start calling names. So I'm going to suggest once you have spoken, don't speak again. One point each. Under creators, what should come to mind? What should I write? I'm typing. Yes, let's go. Kindly unmute and speak to me. I read your slides, so I want to know those areas you don't understand and be able to talk to you on them. Yes, let's go. Should I call names? All right, that's what you want.
Good afternoon.
Okay.
Can you hear me?
Yes, I can hear you. Yes.
Okay.
Nisi, is it Nisi again? No, I won't talk to you. Okay, this is Onuchebe. Yes, please.
Yes. Okay. For copyright, we talk about
Yes.
literary works. That's if you're a writer, works that are written by you actually they come under right protection. If you're a music writer, a songwriter, they fall under copyright protection. Thank you.
Thank you. Can I have another person talk to me on copyright?
Films or dance.
Film,
dance.
Okay, films, dance, yes. Somebody else? These are all the kinds of protection, yes.
Okay, we
There's
have literary works such as books, magazines, plays, drama.
Okay.
Yes.
Next
So
person.
Okay.
Yeah, please continue if you have more points. Yeah.
Okay. And both music companies can protect their brands, their logo. Okay, under copyright, sorry, the music compositions, the sound recording. So that's great. Yeah.
Okay. Do you have another person on the team? Yeah.
Yeah, I want to talk about comedies.
Okay.
Yeah,
Yes.
doing the research, we discovered comedies. Comedians can protect their some catchphrases that they use in their comedy talks under copyright. They can also protect their, let's say, their stage names also.
Okay.
They can through using more or less using trademarks though. They can protect their stage names
I was
using
going to
trademarks.
highlight that. All right, that's cool. Because when you talk about stage name, that should fall under trademark. Thank you so much. All right, so I have a question for the creators. How long would my copyright last? What was the term of copyright protection?
It lasts through the lifetime. Okay, copyright, the duration of copyright lasts through the lifetime of the author, but it's once the author dies, there's supposed to be like a renewal, and it counts 70 years.
There's supposed to be what?
Okay, it lasts about the duration of the author's lifetime, right? So, but it starts counting from 70 years after the end of the writer's death, of the creator's death, sorry. Do you understand what I'm saying?
Can you rephrase? 70 years after? Okay.
After the death of the author, of the creator, sorry. That's the right word. Yes.
Okay, 70 years after the life of the author. Or it will last as long as 70 years after, right? So I want to talk on this renewal. Do we renew copyright, creators? Is it renewable?
I don't think it's renewable, to honest things.
Okay, please express yourself.
Okay, so
Remember,
in that,
only take care. Yes, please express yourself.
sure. I'm not sure. I'm not sure I saw anywhere where they say it was renewable. I don't think it is renewable. In that the work itself, the public has a right to what you have produced or what you have created. So in a way, I don't think it's renewable because I think the public has a right to what you have created, because the idea of your creation is to impact, let's say, to impact humans or to impact public life. So making your work renewable and then giving it only to your estate or giving the right to just you as it is would not be, let's say, will go against public interests. That's my opinion, man.
All right.
That's what I feel.
I have another question before I make my comments. Is copyright registrable? Do we register copyright, and should we register copyright? Creators.
Yes, copyright is registrable, and in fact, although the
the act does not like specify, does not give like a formalities, but it's well advisable that you register your copyrights because it's much more easier to, I don't know if you get what I'm saying.
Yeah, it's easy. I finished that. I want you to finish that thought. I flow with you and I agree with you. So just complete it. It's easier for what to happen.
I feel like it would be easier when there's like an infringement. It would be easier to like
exactly to say who owns what right, right? Who was the first to create that right? Agreed. All right, thank you so much. So ideally, once a copyright or once a work is fixed in a medium, once it is fixed, remember, it does not protect an idea, but the expression thereof. So if it's a book, for instance, but I have an idea to talk about a Mona Lisa or whoever, which we know it's a fact in history. If I take it up to discuss it, the way I express it, Mona Lisa herself or the main things she did or whatever it is she represents, okay? Whatever thing that's copyright work represents, if I choose to write on it or to create a story around it, it doesn't change the fact that I'm discussing Mona Lisa, okay? Another person has a right to also discuss the same Mona Lisa. However, the difference is this: the way I express my own story, the story around my own Mona Lisa is different from the way you express yours. That's my expression. Once I fix it in a medium, such as a book, whether ebook, hardcover, whatever it is, then I have copyright protection. So it is automatic once fixed in a medium. However, we are encouraged to register our copyright so that in the face of dispute, we're able to say, oh, this is a true owner of this work because this work has been existing maybe the last 20 years based on the records with the Copyright Commission. So that's one of the benefits of registration. Now we talked about renewal. We don't renew copyright. First, we don't even need to register it, but if we choose to register it, it's for our own benefit. That's number one. Number two, it is not renewable. Once it's registered, it is registered and that is it. The right continues almost in perpetuity because it lasts the life of the author. And where there are two joint authors, it lasts to the life of the last author who is leaving. It's not until the second author dies, we begin to count their 70 years. Now, inside copyright, we also have moral rights, right? Did anybody discuss that? Because I didn't see that in your work, creators. I didn't see anything about moral rights in your work. You didn't think it was an important aspect, and you people didn't talk about related rights and copyright. Yeah? Somebody wants to speak to me? Who wants to talk about related rights? Who wants to talk about moral rights? Creators.
Okay, hello?
Yes, please.
Okay, based on my own understanding, I think that registering owning an intellectual property both economic and moral rights. Now, based on what I understand, moral rights, they are the rights that accrue to a person by just being the owner. So you don't really have to enforce it, or you don't really have to sue, but it's a right that shows that, okay, yes, I'm the owner of this particular song or this particular lyrics, and it is you're entitled to that, even though you cannot really push forward to enforce it or get damages from an infringement. So yes, that's what I think.
Okay, thank you for that response. I agree to a large extent. However, this is what I think it should be. So when we talk about moral rights, there are rights that are derived from a copyright work. They are both inseparable. Even when I alienate my right in a work, I can't transfer my moral rights. Do you understand? Although in some jurisdiction, I think Botswana or Malawi is one of those jurisdictions where it is alienable. But in Nigeria, I can't transfer my moral right, okay? So even if I do a contract with you, transferring my right in a song, say Two-Face is transferring to me, he can't transfer his moral rights. His moral rights simply means anytime I hear the song, "You Are My African Queen," I must still give credit to Two-Face. This song is by Two-Face. You notice the radio station, for instance, they sing a song or they play a song to us. They always will tell us, oh, this song is by that is a moral right. So he has a right to be mentioned anytime his work is being discussed or displayed or whatever. Do you understand that now? So that's moral right. So related right, who wants to talk on related rights? What do you understand by related rights? Who
For
can get
related right.
related rights? Yes.
Okay, for related rights will be, we'll look at rights as to economic gaining revenue from your work, rights to assign your work, rights to authorize and not that to use your work for
All right.
either.
I heard you say something, okay, while discussing this, and I want to take that, so I used the opportunity to discuss it. You said economic, but you cut it off there. It means a different thing, okay? Economic, yes, economic rights, but thank you for giving us that phrase. It helps us to talk about it. So it's like moral rights, then you have economic rights. These are bundles of rights inside a copyright work or related right whatsoever, okay? So economic right has to do with the financial aspects. Whenever you want to use my song, you pay me some money, isn't it? If you want to transfer my song or do a work of adaptation, whatever, this economic rights arises. So I can alienate this economic right to say, oh, I've sold my song, or I've assigned my song, or I've licensed my song. However, it does not move together with my moral rights. We discuss moral rights. Hope you understand that. So that's economic rights. Now, related right has to do with, for instance, we go to the movie industry, isn't it? The producer of the movie, for instance, would normally take authorship of the work. You agree? So what do you think the artist and the play crew, what are they going to take? They have related rights because they are people who help me to complete my work. There are people who gave support while I was creating my copyright work. Do you understand? So such people, they are not ordinarily entitled to the copyright of my work. However, they have a right called related rights. So this is still a big debate. To what extent will this related right go, especially in the movie industry? How much are we paying them? Are they entitled to maybe, like a yearly revenue from what is generated? Are they paid something thereafter? So that's so I'm open to your questions from here. We can discuss, but first let's talk about inventors. Inventors, you've heard the creators, you've seen what they did with their work, and I believe you learned one or two things from the discussion. So let's talk about inventors. Who should be an inventor? That'll be my first question. Inventors, talk to me. All right, I want to say something quickly on creators because I just went through the chat box now. And when it comes to this 70 years, I'm sure you guys are aware we have a 2022 Copyright Act. I don't know if any of you read it through before doing this assignment. You notice that based on the provision of the new act, these economic and moral rights, or rather the rights in a copyright expires at that 70 years, plus the moral rights. Before now, the moral rights continues to live on after that 70 years. But now, at the end of this 70 years, the moral rights also what? Goes with it. So that's one of the new things this Copyright Act has put in place, different from what you see in every other jurisdiction. I'm thinking Nigeria is the first for now. So we'll go back to the inventors. Yes, who is an inventor? I read through your document. I enjoyed the reading, so kudos to you guys. So talk to me. You guys put in a lot of things there. So you want the creators to also learn. Yeah, so who should be an inventor? I hope you guys didn't employ. Yes, please talk. I'm thinking you employed AI to do your assignment. Yes.
An inventor is someone who makes a new product with original processes in making.
Okay. Any other contribution, please? So we know patent protects what? It can be a process, it can be a product, it can be a combination of both of them. It can also be an incremental value on an existing product or even a process. So that is why you can have somebody patent something and then tomorrow the same person comes with an addition. So we'll call it patent of addition, okay? So I'll take that again. A patent will protect the technology in something, okay? It will protect the process, maybe the process of water purification before now, assuming it was unknown. So somebody comes up for the first time to tell us, okay, I have this patent, and then brings a document to the patent office. It is how to purify water using a particular system that we have not heard of before. It is possible we have different kinds of water purification method, but because we don't have this particular method, maybe this person wants to use charcoal to purify water. You know what I mean? Because inventors, they think beyond the way normal people think. They think outside of the space. So you'll be shocked to find out that even charcoal can purify water, don't mind me. So that's by the way. So this person comes up with this new technology. Already we have water purification system. Do you think you should get a patent? Inventors, please, there's no time. Are we here? Any inventor there? I'm going to call somebody. Can I talk to Gladys Ogo, inventor? Should I give this person a patent? I'm the examiner.
I did not get your question.
So I'm saying there's a system to purify water.
Can you please comment?
Yes, so there's a system to purify water. It is well known. There are various systems.
Please, I did not get your question.
I'm already repeating myself. There's a system to purify water. Any other inventor, I think our network is glitchy. Any other inventor can talk to me. System to purify water. So there's this new system that is unheard of. Should this person get a patent? Or should he be blocked by other forms of inventions out there that purifies water?
Okay, I think you should get the pattern.
Okay, thank you. So your network is glitchy, so I'll take it from there. Such a person should get a patent. Why? All right, thank you, Ogo. Your network is glitchy, so such a person should get a patent. You should get a patent because it's a new process, okay? It's not known already. It's newly existing. However, if in the course of developing that process, he has to boycott my own process or use a good percentage of my own process, okay? Or my industrial steps that I used to come by my own process. It means at best, we should both cross license, okay? It should get a compulsory license, and I also get a compulsory license for two of us to coexist. Otherwise, I'll block the person. He can't use this process until mine expires because I got registered before him. Now, what are the types of inventors that we have based on the Act? Inventors. Inventors, what are the types? Oh, I saw all these things in your slides. Don't make me think it's an AI that developed your material. Inventors, nobody's speaking. It's only Gladys that identified with inventors, so I won't be calling her again. Anyway, we have basically two types of inventors. We have the true inventor, we have the statutory inventor. Who is a true inventor? A true inventor is the person that develops the technology or that comes about the process. This is the person who goes into the field to discover there's a problem in a particular field and by himself puts up a solution to it. answering to that particular question in that field. That is an inventor, a true inventor. As many people that came together to do the work together, that contributed substantially, all of them are true inventors. They can range from 1 person to 100 or much more. So the Act expects that they are mentioned, just like the moral rights under copyright. They are also mentioned wherever that patent is discussed, we credit it back to them. Even in the patent application, if you don't mention them, is a ground for invalidation of that particular application. Now, who is a statutory inventor? Based on the same section 1 of the Patent Act, a statutory inventor is any person who comes to the registry to take up the patent registration. The person who pays to government and says, oh, we came up with this process and we want to protect it under patent. That is a statutory inventor. And this person can be a normal human being, and it can actually be a corporate body. And it can be a combination of both the true inventor and the statutory inventor, whether a human being or corporate body. So we go back to our slide. I think we've had a lot of interactions, so let's move. Let me conclude. I'm not sure I still have enough time. So what are the rights enjoyed by a creator or an inventor? These are some of the rights. They have first the right of exploitation. I say a lot of this in your work, so kudos to you guys. So they can exploit their work, use it directly by themselves. They go into the field, produce the product, sell it, or in a situation where the inventor or creator does not have money, or does not have interest, or does not have the expertise or technology to mass produce it for the world, what does such a person do? It moves us to here, either here or here. Here you have license, here you have an assignment. So assignment is like saying, I have sold my right in this work. Remember, copyright, I cannot assign my moral rights. But for patent, for designs, for industrial designs, which are all industrial property, I can assign totally my rights in a work. However, for license, it means I'm retaining ownership, I'm retaining everything about that work. However, you have a right to use it, to exploit it, whether to sell, to import, to export, to do whatever you choose to do with that work. So also a right holder can what? Export, it can import, it can manufacture, in the name of exploitation and all that. So you can also have right to surrender. The Act allows that. I may come and register a patent and tomorrow I wake up and say, oh, I'm no longer interested in this patent, so I surrender. And then as soon as I surrender, it falls back into the public domain. So find out that it's not just when a work expires that it falls back to the public domain. It can actually fall into the public domain through an act of surrender. So you just need to write to the registrar to say, oh, Madam Registrar, I'm no longer interested in this patent application, so I surrender my rights in it. So let it fall into the public domain. It's my contribution to the public. So I have a right to sue. If somebody should infringe on my right, this is one of the rights I also enjoy. If you use my work, whether on social media, especially for creators, with all the new technology we have there, you see people, so many artists since the COVID, so many people on social media creating different kind of works, exploiting people's work without permission. Thankfully, the new Copyright Act is trying to catch up with some of the loopholes that the old act allowed, so that the creators can actually have a good enjoyment of the rights that they have created. So that moves us to what's next at the expiration of a work, whether it's the copyright, whether it's the patents, especially for industrial property. I won't want to involve copyright because now it's only going to expire after 70 years. And you agree with me, it's a very long time. Not so many people will be alive to even know when it expires. Let's talk about the industrial property, where you have the trademark, the patents, and then the industrial designs. We've discussed under industrial design the similar content, where we'll talk about variation of the packs or the designs or the logo of the in-domain wrap. So usually that's what happens. And when I vary it, I come back and register, and then my registration starts counting afresh. There is also expiration. When it expires, it falls into the public domain. It can also expire based on the fact that I didn't pay my renewal fee. I can abandon it by not paying my renewal fee. Because for trademark, for instance, you have to renew it. For industrial design, you need to renew it. So when I don't renew, even for patent, okay, can the inventors talk to me? Does patent last forever? How many years is a patent supposed to last for? Inventors, you didn't participate so much. Only Ogo has spoken to me. So I'd like somebody else to speak to me.
I think a patent doesn't last forever. It lasts for the duration of about 20 years.
Yeah, so within that 20 years, how does it operate? Is it like I register it and that's it, I go to sleep and it's existing for 20 years? What happens? Any other person, please? Inventors, what happens to a patent? Once I've registered the first year, what happens? How do I sustain it for 20 years? I'm giving you clues now. What does the act say? Did we read the act? I'm hoping you didn't give your work to AI to develop your material because you guys came up with a beautiful content. What's going on? Why are you not contributing in class? So when it comes to a patent, it lasts for 20 years, but it's not automatic like the copyright is not. So the duration of that 20 years, I'm expected to take up annuity yearly basis, on a yearly basis. So every year I'm supposed to pay government what is called annuity. In other clients to call it renewal fee. So I'm going to pay government a renewal fee to say, I'm renewing this patent from the date it expired to this current 1 year. Maybe the patent was registered, today is on 14th, on the 13th of July, 2022. So what it means is on this date or around this date, it could be 1st of July, bring an application to say, I want an extension by 1 year. You can only renew by 1 year. So you see people, they can come and say, I'm renewing for a couple of years and they pay for like 5 years in a row. That can also happen, it's allowed. So the registrar would document it in a register called the patent register. So moving forward, but if I don't renew every 1 year, what happens? Can somebody talk to me? If I don't renew, what happens? Inventors. All right, so I have just 5 minutes. So if I don't renew, it falls into the public domain, but I also have a grace period. Yes.
I think failure to renew it yearly makes it to fall back into the public domain, and then you like the exclusive right afterwards.
Yes, however, the registrar can actually forgive that if you come back within a grace period, I think about 6 months, and then bring your application to pay the fee. The registrar can forgive that. Yes, so what creators and inventors should do, because we live in a world where people ought to, cooperate more or less. No one person can exist, do you understand? No one person can survive on an island. The same thing happens with businesses. So I'm a fan of open innovation. Open innovation is simply saying, I have this technology, you have that technology. Let's come together, put heads together, and see how a combination of our technology can help us work better, can help us invent something new, can help us make better use of what we already have on our various tables. So it's called open innovation. Companies like IBM, they do a lot of this. So many tech companies, they operate based on open innovation. Now, what should a creator and inventor do as soon as they derive a work or they conceive a work and they start working on it? Start also to consider protection of that work. So talk to a lawyer who is going to advise you, or a intellectual property professional who is going to advise you whether you should get a patent rights, trademarks, or get both, including industrial design. Now, invest in R&D and development. We should have a lot of investments so that ideas will keep coming up and we keep creating and innovating, okay? You should go into partnership. Partnership would be you're a small business, somebody operates a bigger business, and you think, if I give my product to this person to market for me, for instance, I'll get more popular and I'll get more clientele. Why not? Please do it. At the end, you get your money. Sign agreements is very important. It's very important. NDA, do you understand? Non-disclosure agreement, confidentiality clause in contracts. All these are important in order to openly innovate, because new rights will be bettered. So who's going to own the new right that is bettered? So you people should have an agreement. You should cross-license. Cross-license works especially in a particular industry where you see maybe shoe industry I manufacture leather, and then you manufacture the sole of the shoe, we can actually cross-license. So you're not paying me, I'm not paying you. You supply me the leathers, I supply the soles. And at the end of the day, you make your own design, I make my own design. Isn't that perfect? So that's a way of cooperating. And then at the end of the day, smile to the bank, I smile to the bank. Thank you so much. I think my time is long spent. Thank you for listening and thank you for participation. I appreciate you all.
Thank you so much, Ms. Onyekachi, for that wonderful presentation. It was a pleasure listening to you, for letting us back from your wealth of wisdom. I was writing and I kept writing, and now my pages are full. So thank you once again. We'll be observing a minute interval just to take a picture. Everyone, please turn on your camera, put on a smile, take a screenshot, post it on your different social media pages. Please turn on your camera. Yes, that smile. And your best one. Thank you. Please post it on
Thank you
your
very much. While you are taking the pictures, I would like to inform our moderator that our second mentor is on the call, so you can call on her after we take the picture. Thank you very much. Let's smile for the camera.
Okay, please remember to post on your social media pages. Tell them about Jiipcc, tell them, share what you've learned, the lessons of today, share your knowledge, don't hold it. And then I would like to call on our second speaker. We read out her profile a few minutes ago at the beginning of this session, so we already know about her. Ms. Shukrat Amusa. Please, you have the floor, ma'am. We look forward to sharing an exchange of knowledge with you.
Hello, everyone.
Hello, Ms. Amusa.
Good evening. Can you hear me?
Yes, ma'am, we can.
Okay, I'm so sorry I didn't. I had to attend my children's graduation. So I think our other speaker, by it has done justice to the topic. So I'm just going to take us through the aspect of patents and the IP rights that are applicable to inventors, basically. So we say inventors. What do you mean by inventors? That's people that are doing something. Probably they are doing something in a new way, or they're probably solving a particular problem. So it could be a problem as small as putting straw in a water bottle. What problem does that solve? It solves the problem of water smearing while driving. So the straw allows you to be able to drink water and the water will not fall in, right? So that's what invention basically is. It doesn't have to be ions and batteries. It's just something that can improve something or probably provide a new way of doing something. So what type of IP is applicable to inventors? So we are going to be looking at patents. And when I say patents, we have three broad categories under patents. We have patent itself, we have industrial design, and we have the plant patent. On the other side, we can also look at trademark. Probably when they probably invented something, then they want to name this invention. That is where trademark comes in. So when we look at patent, what is patent itself? So patent, we say, is an exclusive right granted to inventors. It could be a process, it could be a product, it could be an equipment that provides a new way of doing something. That's what patent is. So or probably we can also say patent is just like a trade by barter between the inventor and the government, whereby the government gives the inventor a 20 years protection period, and in return, the inventor gives the government a disclosure of the invention, so that if that 20 years expires, the patent goes to the public domain and anybody can pick up that invention and work on it. That way, that invention also benefits the society. So let's say I'm an inventor I've created something that can provide a new way of doing something. Let's say, what's our greatest problem in Nigeria at the moment? Okay, maybe there's a way I can withdraw money in my house. I don't have to go to the bank because people don't like to go to the bank. And I said, okay, fine, government, this is it. I've created this invention that can allow people withdraw money from their bank without going to the ATM. And the government say, okay, fine, let's do a trade by barter. I will give me the invention and I will give you a 20 years exclusivity right. So once your 20 years expire, I am going to put that invention outside so every other person can benefit from that invention. But they can't patent it again, except they do something, they improve on that invention. Now they can now patent it and it goes on like that. So patent lasts for 20 years. So that's what patent is all about. But now when I say patent, it doesn't mean you can just bring something and patent it that way. There are criteria for patentability. Before you can actually say something is patentable, number one, it has to be new, novel. Now, when I mean new, I don't mean it has to be entirely new. It could be an improvement of what has been on ground before, but at least there's an element of novelty in what you are doing. This patent now, it could be a product, it could be a process of doing that product, and it could be an equipment. So when that equipment is new, then you pass the novelty test. Then we now come to the inventiveness aspect. Inventiveness is also referred to as obviousness. That is, your invention should not be obvious to somebody that is in that field. For example, you've created an invention, and the process of creating that invention, you added 1 plus 1 together and arrive at 2. That's obvious. It means anybody can just carry it and do it. That means you don't even need your description. You don't need a patent application before you can actually create that product or that equipment. So your invention must be new, it must not be obvious, and it must be industrially applicable. When I say industrially applicable, I mean it's something we can mass produce, because why will the government give you 20 years for something that is not even mass produce? Something that can just be one, then that's not feasible, right? So your invention has to be new, it has to be non-obvious, and it has to be industrially applicable. So you have to meet up with these 3 criteria. You can't have one and not have one. No, the 3 have to be present. When you have those 3 criteria, we now have to look at it now. This invention, is it actually patentable? Because there are some things that you can't patent. You can't pretend something that exists. Like you can't pretend like I created oxygen. You can't pretend something that exists in nature. So there are some things that we can't actually patent. So it must have a patentable subject matter. Your patent title should not be how to commit suicide in 5 minutes. So things like that, it might pass in some jurisdictions, but in Nigeria, it definitely will not pass. So it has to be new, it has to be industrial applicable, it has to be inventive, and should have a patentable subject matter. So those 3 criteria are what will grant you patent as an inventor. So now you've been granted patent. You have 20 years to work on that patent. Within that 20 years, you now have to look at what Barrister Kati mentioned earlier. Look at the people you want to invest with. Look at partnerships. You want to cross license, because if you don't work that invention, it means you won't be able to benefit the amount of money and the labor and the sweat you put into creating that invention. So you don't just collect your patent certificate and put it in your wardrobe. It will make money for you. And doing that, it means you are just wasting the patent. Why don't you license it out to somebody that needs it? Or partner with somebody else that can use it? So patent gives you an exclusive or exclusionary right. Most times it's exclusionary because the patent is not always entirely new. If you are improving on a patent that's already existed, you can't have exclusive rights on that patent because somebody's patent is already in that patent, except you get permission from that person before you can actually have exclusive rights on that patent. So what you have most times is exclusionary rights. And that's why we say patent is a negative right. Negative right in the sense that you don't have the right to work on that patent yourself. You can only give other people to work on it. So it depends on the aspect you're coming from. So now let's look at industrial design. Industrial design, we call it, sometimes they call it utility design. sorry, patents. Now, in foreign countries, they call it utility patents. So you might just be confused. They call patents utility patents. Why they call industrial design patents? But we call it industrial design. So in case you are reading an article and you find utility patents or design patents, to understand better, utility patents is the same thing we call patents, while design patents is what we call industrial design. So for industrial design doesn't protect how your invention works. It only protects the aesthetic, the ornamental object of that, the ornamental characteristics of that object. How beautiful the design looks, that's all. It has nothing to do with the technicality or the functionality. It is just how beautiful it is. Let's say, for example, you see sometimes there was a time we used to have standing fridge, right? Then later they invented standing AC. And then we were like, oh, this AC, is this AC a fridge or is it AC? So those things that attract you to a design is what we call industrial design. You see Coca-Cola, the shape of Coca-Cola bottle can be protected as industrial design. But Coca-Cola decided to opt for trademark because it has a longer protection period. So as an inventor, you have to have an IP strategy. And this is where the strategy comes in. We spoke about it last week. Okay, fine, you've created something. This thing I've created, do I want to present it or do I want to keep it secret? You have to decide. What exactly do you want to do? Which one do you think will last you longer? Which one is beneficial to your company? Do I want to have industrial design or do I want to use trademark to protect the 3D functionality or the 3D aspect of this design, of this product? Because design will give you only 15 years. You have 5 years consecutively, 3 times, that's 5 times 3, 16 for industrial design. And you have till infinity as long as you renew your trademark and you maintain and use it. So you need to know which one works for your business. So patents protect the technicality, how it works of the invention, while industrial design protects the functionality, basically. Now, when it comes to plant patents, what does plant patents do? Plant patent is mostly for farmers, plant breeders. It protects plants. I'm an horticulturist. I studied horticulture. So let's say I want to grow a plant. I've propagated the plant, and maybe I want to do budding or cutting or layering, and I have that plant. I have to look at that plant and see, can I actually get a plant patent for this plant? Plant patent also has criteria. It has to be new. It's not as if you go outside in a nursery and you just pick one plant and you say you want to present it. It doesn't work that way. The plant has to be new, and we call something DUS, D-U-S. It has to be distinctive. It has to be uniform, and it has to be stable. So you have to watch that plant while it's growing. That, okay, this plant is actually distinctive, is uniform. That is, while it's growing, it's having the same characteristics, and it's stable. So those are the criteria for plant patents. If you don't have that criteria, you actually can't meet up with registering plant patents. So these 3 things are under patents, other patents. If you read the Patents and Design Act, but the plant patent is not under the Patent and Design Act. It is under the agricultural sector. So you can just read more about that. So when we now cover the patent, we cover the invention. Now I want to enter the market. What do I need to protect my invention? Then you now look at trademark, because trademark is what we use to identify and distinguish one brand from another brand. So I have an invention. Somebody has come to me to put that invention in the market, but I want to distinguish my invention from those of others in the market. That is where trademark comes in. So mostly for inventors, you have to look at patents, design, maybe plant patent with the plant, and trademark most of the time. So I think I'm just going to stop here so the presenters can present. Thank you.
Thank you so much, Mr. Musa, for that insightful presentation and for letting us share your knowledge. It's a pleasure. And at this stage, we'll be giving each group 10 minutes due to shortage of time to share their own presentation with us. So every group just have 10 minutes. I will advise us that we stick to time. Group 1, are you ready? Please go ahead. Or it need not go in a particular order. Any group that is ready, please go ahead.
This is group 2. Can we go ahead? I don't know.
Yes, please.
Sorry, I was trying to share my screen, but group 2 can go ahead. I have to fix it. Please, can someone help me with sharing the group 1 slides, please? I'm unable to share it from my end, so I can just continue.
Anyone in group 1, can you share the slides? Okay, thank you, Lucy.
Okay, thank you very much. This is first slide. Thank you. So, good evening, everybody. Please, hope you can hear me clearly.
Yeah, we can hear you.
Oh, so
Is it slide showing?
yes, it's showing now. We can see
Okay.
it. Yes, thank you. Okay, so according to the table of contents, we've been introduced to what intellectual property is generally. So we're going to be treating specifically creatives. So we're going to say we're going to look through the types of creatives that can be protected. Yes, we're going to look at the importance of contract reviews, the remedies for infringement, and we're going to conclude on what's next after the remedy infringement. Okay, so for an introduction, what is intellectual property? Intellectual property generally is the creation of minds, such as invention, literary work, artistic work, design, symbols, names and images used in commerce, anything. So in specific, what is creation? Like, what are creatives? Creative relates to or involves to the use of imagination, the use of original ideas to create something. So when we think of creatives, we are going to make reference to the copyright. And in Nigeria, copyright is regulated by the Copyright Act, the most recent one of 2022, and the National Copyright Commission, which is the body that regulates copyright. So specifically, copyright. Section 2 provides for the creatives that are eligible for copyright. They include literary work and musical work. They include artistic work, broadcast, audio visuals, and many more. Please, so what is the importance of intellectual property creatives? Can you move up? Okay, so the importance of you protecting this creative is for financial benefit. When your creatives are protected, you'll be able to gain financial benefits from it. As our mentor has said earlier, you have economic rights from your copyright. Yes, you enjoy economic rights. So you also have reputation and recognition, because this particular creative will be recognized as yours, and you have such reputation as you'll be credited for it. In addition, you have creative control. That means you have the right to use it the way you want. You have the right to exploit it, or however you want to do that. So it encourage more innovation. So I've talked about the types of creatives, like types of creative, and I've mentioned the Copyright Act. So move to specific. We'll start from literary work. So how can literary work be protected? So Section 9 of the Copyright Act grants exclusive rights to authors to do whatever to do and authorize the doing of anything to their work, such as reproducing, publishing, performing, distributing, broadcasting, and publicizing their literary work. So according to Section 109 of, that is the Interpretation Act of the Copyright, it provides for what includes literary work. It includes poetic work, novels, stories, plays, stage direction, and many more. Please, can you move to the slides on literary work? So your music, the poetic work, novels, stories, they can be protected by using copyright. However, there are specific things that can also be protected by trademarks, such as probably the designs or a particular brand name, and so on. Also, music has been protected under the Copyright Act by virtue of section section 11 or so. So, but music is also protected by Section 9, because according to the Copyright Act, it says literary work and musical work. So visual art includes painting, name of artist, illustration, it could be a carving, it could be any work of art. So this is also protected by Section 10 of the Copyright Act, which provides it grants exclusive right to authorize the reproduction, publication, broadcast, and so other exclusive rights to the author, like to the creator, to exploit such art in whatever they want to use. So there are certain apart from copyright, there are certain I would say certain names of brand that is used as regards to visual art that can also be protected by trademarks. I'm saying the name of the brand, the probably logos and the rest. Software programs, the code specifically is classified under literary work, like software program that's stated in Section 109 of the Act. So it provides that yes, your software programs can also be protected by copyright. Comedy, okay, so let's move to comedy. The stage name can be protected, jokes, phrase or slogans, the brand. So the jokes can be protected by copyright. However, the logos, brand name, and stage name will be protected by trademark. So as regards to fashion, the logo, brand name, and associated fashion brands are protected by trademark. However, copyright protects the fashion itself. So as regards to broadcasting, Section 13 of the Copyright Act provides for grants exclusive rights to authors, and it states how they can exploit this art. So what is the importance of contract and proper contract review for creative? You can't just say yes.
I don't know where to say. Annie.
You can't just conclude that yes, I've
I don't know where to say. I have a presentation.
But it is necessary. It is necessary. There's a properly aligned.
Like some seconds. The person that is before me has already seen it.
Please, can you mute your mic? So it creates, like, when there's a defined agreement, yes, the contract is clearly stated, you'll be able to have a legal protection, because you'll be able to show that yes, this is my protection. You have legal protection. You have a protection of intellectual ideas, because it will flow out there in the public. You have the authorship to it. Fair monetary value, where you license it to another person, you'll be able to get economic right from there. It protects the creative interest, like the protection of intellectual ideas. And when you decide that yes, I don't want to license, your licensing agreement is over, you'll be able to have a fair termination to such contract. So what are the remedies provided for infringement of this right? You have the right to bring action before the court. You have the right to sue for damages, claim damages, injunction. I have the right for letter of demand that, this is what I demand as regards from the infringement of my right. So in conclusion, for copyright, for a creative to be eligible for copyright, it must be original and it must have a fixed mode of expression. Thank you.
Thank you very much, Group 1, for that presentation. And thank you for finishing reading time. Group 2. That was a beautiful presentation. Are other groups ready for theirs? Remember, we have 10 minutes for each presentation.
Yes, let me share my screen now, please.
All right. Which group?
Group 2. Can you hear me?
Yes, we can. Go ahead.
Okay, this is group 2 presentation, and the topic is intellectual property for inventors. In this presentation, we'll be learning about the types of intellectual property, the meaning of intellectual property, the types, patent rights, inventors in the engineering industry, that's how they protect their inventions under the engineering industry, how they protect their inventions in the communication industry, how they protect their inventions in the medical and pharmaceutical industry, and how they protect their inventions in the tech space. Now, the types of intellectual property. Before I get to the types of intellectual property, we already know the meaning of intellectual property, the protection of the creation of our minds, and all the rest. Then we have types of intellectual property. Sorry, can you hear me?
Yes, we can hear you.
Okay. We have the patent, which grants exclusive rights to the inventors for their inventions. And then we have copyright, which grants exclusive rights to owners of books, music, artwork, and all the rest, like Group 1 has already presented. And then we have trademarks, which grants protection and differentiates logos of different brands and symbols. And then under the patent rights protects invention of inventors, which is what we are going to be looking at today. However, not all inventions are patentable, as we are seeing in the fourth slide. It is only possible to acquire a patent where that invention is new, non-obvious, and useful. The invention is new when it is one that has not already been used. It has not been disclosed to the public. That is what makes an invention new. And then the invention is regarded as non-obvious if it results from an inventive activity. So it is important to note that the patent right holder may not necessarily be the inventor. Just like one of our mentors have already mentioned, the two types of inventors we have the true inventors and the statutory inventor. So the true inventor is the person that files a patent application that has not been used before, that is provided that the application, the true inventor, is the one that makes the invention firsthand and files for it, while the statutory inventor is the one who makes an application for a patent that has already been used by someone else, but does it with the consent of the inventor, or maybe succeeding when the inventor has died, he succeeds the inventor on that patent and applies for it. Then when acquiring a patent on one's invention also comes with benefits, just like other intellectual property rights. For instance, a patent acquired in respect of a product confers on the patentee it gives the patentee exclusive rights, such as making, selling, importing of the product, and also suing when this same product or the process of the product have been used by someone else, and he sues and gets economic rights or benefits from the product. Now we go into how inventors in the engineering industry, how they protect their invention. Sorry, can you guys hear me?
Yes, we can still hear you.
Okay, how inventors in the engineering industry, how they protect their intellectual property. So in the engineering industry, the robots, machines, tools are made in the engineering industry. How to cure illnesses are also made under the biomedical field of engineering. And these rights are protected because under the mechanical engineering, the development of robots in collaboration with AI is one of the leading innovations we see in the society today. And the engineering industry is responsible for the development of various machines, which enables them to carry out activities. So it is protected under the engineering industry because without the protection of these inventions by the engineers, some other person could have taken it and formed it into something else. Sorry, that's not in the slide. And then we have the inventors in the communication industry, how they protect their inventions. Inventors in the communication industry use IP to protect their innovative ideas and creations. And by leveraging on these intellectual property rights, the inventors can protect their innovation, establish market exclusivity, and attract investments, and also commercialize their intentions more effectively. And then some of the examples of these inventions are migrations from 4G to 5G, the telephone, the email, and the social media platform like Snapchat, Facebook, Twitter, the new social media platform Threads, and Instagram. Then we have inventors in the medical and pharmaceutical industry, how they protect their invention. And as we all know that the inventions in the medical and pharmaceutical sectors it is very tasking and it costs so much to get. So like getting a patent for this invention is very necessary. And then, sorry, I did not say this from the very first start, but the patent that is used for protecting invention lasts for 20 years. So when a pharmaceutical company first develops a new drug, it is initially sold under a brand name by which the clinicians can prescribe the drug for use by the patient. Now, only the pharmaceutical company that holds the patent is allowed to manufacture and market that drug and also make profits from it. So now once the patent have expired, the drug can now be manufactured and sold by other companies. But like as one of our mentors have already said, that it is not every time that a patent expires on a product that it can be open to the market. They can redesign, and in that case, they will also still get rights to it. Now, just for our time, I'll move on to how the inventors in the tech space, how they protect their intellectual property. The inventors in the tech space, they have numerous inventions and advancements, and then some of them have been mentioned in the slide. If you're following up in the slide, we have the CubeSat, we have the reusable rockets, we have the space tourism, we have the internet satellites, we have the 3D printing in space, we have the space-based solar power, and many others. And it is very important that the inventors in the tech space, they protect these rights. Then in the next slide, there are examples in engineering, the intellectual property in engineering. We have the car production. And they say a Bugatti is a custom-made car which only sells to the 1% rich other than the masses. And this is the concept of someone's ideas which was utilized and enjoyed as an intellectual property. We have an example under the communications, the 5G broadband for cellular networks, which cellular phone companies use to provide connectivity to most cell phones. And that is an improvement of the former one. Some of us are still using 4G, but however, some network brands have upgraded to 5G. That's an example of intellectual property under the communications. And then we have the medical and pharmaceutical part of the invention. An example is the recent invention in the COVID-19, the vaccine for prevention of COVID-19. And then we also have in the tech space, like I've mentioned so many of them. An example too is the SpaceX, the Starlink, the OneWeb, and all these inventions are people's intellectual property. So to the next slide, we have cases of lost revenue due to failure of IP management. In music piracy, we have the widespread music piracy and illegal downloading have significantly impacted revenue for artists. It has led to reduction of sales and all the rest because they have not been able to manage their intellectual property. We also have under the pharmaceutical patents, the generic drug manufacturers infringing on pharmaceutical patents. Sorry, the generic drug means, I think, when the patent has expired for that product and now it has entered into the market for users, and now it infringes on the original owner's rights, and then it leads to lawsuit for the original owner. Why? Because of lack of management of intellectual property. And then we also have in the I think that should be the communication part of it. We have the Kodak's failure to protect digital camera patents. Now, the Kodak is a pioneer in digital imaging. It has failed to adequately protect its digital camera patents, and it has resulted in missed revenue opportunities as competitors capitalize in similar technologies. All these things are the cases of lost revenue, which points to the importance of protecting our intellectual property as inventors under patent. Now, before I go to the conclusion, it's also necessary to know that it is protected in law under the Patent and Designs Act, right? Then the conclusion is that before you seek to get a patent for your product or for the processes in making your product, you need to conduct an IP research before starting the project, file appropriate patents when it's time, or trademarks or copyright, depending on which one covers that product that you're doing. And then you also seek legal advice and file the necessary applications to protect your IP rights as early as possible. So from all these things we've learned, it's also pertinent to know that intellectual property is very important as inventors and innovators. And then we can protect them through patents, trademarks, copyrights, and can get revenue from them if we manage it well. Thank you.
Thank you very much, Group 2, for that presentation. That's another job well done. Thank you for also keeping to time. We have the next group. Group 3, are you ready? Or any other group that is ready to save time? Is the next group ready? Oh, okay. There are only 2 groups. All right. There's an error on my part. Okay, thank you so much, everyone, all the presenters, the screen sharers. Thank you for that. I would call on our mentors to comment on the slides, on the presentations given by the mentees. Do any of you have any comment or anything addition to say based on the presentations that I've given? Ms. Onyeka, Ms. Amosa.
All right, thank you so much, moderator. So I'll first address the question I'm seeing on the chat box. It says, Ms. Onyeka, my question is regarding patent renewal. Is it that after the expiration of 20 years, it can't be renewed again, or it's like industrial design where if it can be renewed or registered, if something is added? All right, so for patent, I've already discussed something similar to this question. I believe should address the question. Once a patent expires, it falls into the public domain, which means any person, just like with the generic drug that the presenter talked about, which is beautiful, by the way, you find that somebody else can then begin to use it freely without paying you royalties. That's the difference. So what it means is while a patent subsists, for me to use it, I need your consent, and in exchange for that consent, I'm paying royalties for its use. So until it expires, I can't use it without your permission. That's without paying you royalty. Now, when it expires, it is expired. That's just what it is. It goes back to the public domain because it's something you exchange, like Amos had put it. It's like a trade by barter. Government gives you in exchange for a disclosure, full disclosure, without which you can't even get a patent grant. That's by the way now. It is different from industrial design. Industrial design is basically like I told you, branding is like a concept of both trademark, a combination of both trademark and industrial designs. So what industrial design helps you to achieve is because that particular product is still in the market, and because trademark lasts in perpetuity, so it helps you to kind of also make the design to last like forever. So as soon as it's coming to its expiration dates, you bring another application to vary the existing design. Maybe the wrap changes in color, or you just put 1 or 2 things around the wrap to change that particular design. So it continues to exist in combination or because of your trademark. Because for instance, the trademark lasts forever. Now your design expires. How do you want Indomie to continue to sell their Indomie if the wrap is expired? It means I myself can do my own Indomie and use their logo design and the wrap and all that to also sell in the same markets. How do we differentiate both? So this is what industrial design helps to achieve. So patent is quite different from this. However, in other climes where we have patents of addition, people would ordinarily at the expiration or before the expiration, they bring like a little bit of improvement on what is already existing and want you to register it. Sometimes they are lucky, it is accepted by the registry, and then they file, and then they get a patent for this new improvement. And remember, a patent can be a process, a product, or an improvement thereof. So an improvement ideally can entitle a particular invention to get a patent grant. However, some of the innovations in the registry today, under patent registry or under patent and design, apart from patents, which we have under patent office, we now have utility model. Utility model is a smaller kind of patent. It lasts for 10 years as against the 20 years of the real patent. So when I have a patent of improvement or an addition, patent of addition, rather than request for a new patent, of which I could request, for the registrar in our wisdom will refuse and tell me to bring an application for utility model. So utility model gives you 10 years. So it covers for all those little bits of additions, because we already know what the inventor has in mind. Usually their aim is to block others from gaining access to the markets. And so that is not encouraged, because people should be able to innovate, cross license and whatever, and anything in the public should not be taken back from the public and then protected and then you ask the public not to use it again, because once it's expired, it's already in the public domain. And government is always looking forward to the expiration of 20 years so that people can walk around that product or that invention and create something new for the enjoyment of the society at large. Thank you. If there are other questions, I'll be glad to take them.
Okay. This is the question and answer session. Do anyone have any question for any of our mentors? I think Ms. Shukurat is still on the call. If any of you maybe want to pick our mentor's mind or have further questions to ask regarding all that we've discussed, please unmute yourself and ask, or you can just type it on the chat, on the comment section if you are too shy. Questions, questions, questions. Please ask. We're out of time. Okay, I'll begin with this one. Ma'am, we have here the question: what court is responsible for handling cases of infringement on creatives' intellectual property?
Is that for me? Okay, so that would be the Federal High Court. All the acts that governs our intellectual property rights in Nigeria, whether it's a trademark, the industrial design, the patents, they all specifically state that the Federal High Court has jurisdiction to hear any matter on intellectual property. So that should be the right court.
Thank you very much.
I would like to add to what Vice Chancellor said. So, like we know, IP is territorial in nature. That is, whatever we register in Nigeria stays in Nigeria. So, for that reason, that is the reason why all court cases are directed to Federal High Court. You understand? IP is territorial in nature. So we have to add that at the back of our mind. So if you leave Nigeria, go to another country, don't expect that your IP is also protected in that country. It's not.
Ms. Shukrat, perhaps it's from my end, but I'm please, can you mute yourself?
Can you hear me? I really can't hear you as well. So I don't know if it's from my end or from your end.
Okay, thank you
I
very
think it's from your end.
Thank you very much. Everyone, please, can you mute your mic? check if your mic is unmuted and muted. Thank you for that. Okay, our next question is, what is the best way to protect the IP of a creative? Any of our mentors can take it.
Okay, so best way to protect IP of a creative. I actually want to believe this week is for IP and inventors and why we treated IP and creative last week. But either way, when you talk about creative, the first thing that comes to your mind is creativity. And how do you express creativity? It's either you express creativity in a written form, oral form, or probably visual form. So most times, creative itself is basically protected by copyright. And that's why we say copyright protects literary and artistic work. However, when we say creativity, sometimes we kind of extend it to invention as well. But when it has to do with invention, then you know it is patent. Then the brand name aspect is covered by trademark. So your invention can actually have all aspects of trademark. You could have the patent for the invention, that's the technical aspect of the invention. You could have trademark for the brand name. You could have copyright probably for your advertisement of how you advertise your brand. Maybe you have unique images you created, or you have song you sang just to market the product. That's how you protect it by copyright. And industrial design for the aesthetic aspect of the product. So all these four types of IP can be found, like you can find them in a product, or it can be used to protect a product. Depends on which aspect you're coming from. I hope that explains it.
All right, I would just like to add a comment. So in addition to what Amusa just said, especially if it has to do with like apps or things that have to do with online businesses and stuff like that. So you see creators who want to say, oh, I want a patent, or I want to protect on that trademarks. Ideally, it should be copyright for the software, for the website, the workings of the website and what have you. Why trademark is for the name of the website, for instance. However, when it's a new kind of business and the business idea is yet to be protected anywhere or yet to be seen or heard of, such persons in Nigeria will also be protected under what we call business method. Okay, so it's a new business, is not heard of before, and then you need a protection and you don't want people to come and push you off it. And I think the protection lasts for about either 7 or 8 years. So it's a little bit lesser than what you have on the utility method. So you can actually add that. And then depending on what your functions are, then you also look at some classification under trademark, depending on what that app does. You can look at maybe class 9, class 42. So and then depending on the specifics of the acts, you want to also add some other acts classes, especially class 35, if it has to do with any form of online business and what have you. So these are some of the ways you can also protect. Yeah.
Okay, thank you very much for that. The next question would be, looking at the use of IP in communication, technology, space, etc., the use seems to be almost the same. Hence, does the impact not extend beyond patents, copyrights, trade secrets, and trademark? Any of the mentors can take it too.
Okay, if I understand this question, the impact of the use of IP in the communication and engineering industry, it's still based on what we had said earlier, especially if you look at how Amusa had also addressed the previous questions. I think the question has just been rephrased. Sometimes trademark or the creativity of a particular inventor or a creator, it cuts across. Recall my slide. I had shown you maybe on that slide 3, where you can have an overlap. So I think that is what this person is talking about. So it goes beyond a particular genre of IP. So sometimes you see somebody come up with something and it cuts across trademarks, patents, copyright, industrial designs, and even trade secrets. So it is possible, especially in the communication industry, the tech industry, where it has to do with software, the soft codes and stuff like that. So you can actually have that. A technology that uses software, you're talking about copyright. If it's a new technology is not heard of before, you're looking at patents, the name of the products, you're looking at trademark, the designs of that particular product, the outer aesthetic qualities, the beautification and stuff like that. You're looking at industrial designs. And beyond that, you have things, the workings of the app or the manipulations and stuff like that is not known to anybody that can also be covered under trade secret. So sometimes you can actually have huge overlap cut across all aspects of IP. Yeah, sure. Thank you.
So just to add, if I ask you, actually, there's nothing new under the sun, right? So most of these communication companies or tech companies, they are basically doing the same thing. It is just something small that is different from whatever they are doing. So it is that something small that gives each communication company or tech company their own originality. And that is what they now patent or trademark or copyright. Communication, what are they selling? They are selling technology, right? Airtel, MTN, Glo, they are all doing the same thing. They only have different names. And it is that name we are able to use to differentiate them. If they don't have a name, how do we differentiate Airtel from MTN? So most of them, when it comes to use, they do the same thing. But in the marketplace, right, everybody has the right to come to the market to sell. The only thing is, how do I want my customer to be able to identify my product? And that is where trademark comes in. So each brand or each telecommunication company have their brand name. And most times, some of these tech companies, they do what is called cross-licensing. Like Barrister Onyekachi mentioned earlier. I have something that you need, you have something that I need. Okay, come, let's cross-license. Give me your own, let me take your own. And let's see what you can do with it. That way, they might not even have to pay each other because they are cross-licensing. So you have to understand the type of IP that is in the industry you find yourself in. And if you have all the types of IP in that industry, then fine. You need to add them to your IP portfolio so I can get better investors to invest in your business. Thank you.
Okay, thank you very much, Mr. Yenka and Ms. Shukurat. We have the final question, which is, will it be safe to ask that, okay, will it be safe to say that IP only has a positive effect in the communication and other industries?
Can you take the question again?
I said, will it be safe to say that IP only has a positive effect in the communication and other industries? That's in the communication industry and other industries at large.
Sure, it has a positive effect across all industry. You know, in my explanation of what IP is, I said IP is a way of life. As you are all seated, you are wearing clothes. That's textile industry, right? I have glasses on. The moderator also has glasses. Okay, we are entering what's it called? Ophthalmologist and the clinical aspects. Do you understand? So that's an industry on its own. We have both eaten this morning. That's food industry on its own, right? We are wearing maybe undergarments, different designs. We are wearing wristwatches, ornamentals and stuff like that. We're wearing perfumes, body creams and stuffs, beautification industry. We are wearing makeups, you know, all kind of things. It cuts across. So IP for me, it's a way of life. It just goes beyond the creativity of the mind. It's more or less what I wake up to do every morning. That's intellectual property. What I wake up to see every morning, that's intellectual property. What I wake up to even say every morning, oh, I want to go to Wuse Market. Wuse Market has become a brand name on its own. Everybody knows when you go to Wuse Market, this is where you get. It's a geographical indication. Is a location. Okay, that's another thing we have on that trademark, geographical indication, for instance. So when I say something about what's all these drinks now, champagne and stuff like that, there are places existing somewhere, and it's also the name of a drink. So IP is just a way of life. If you mention the name of a church or a mosque, it's also a brand name. So IP cuts across our industry, whatever schools, that's also an industry. You find IP there, whether the books they use, the name of the school, the uniform they wear. So IP cuts across everything. So it has an impact in all industry. Thank you.
Okay, Mr. Mosa, would you like to join in?
Yes. I would like to address the question in a different dimension. So yes, IP is a way of life and cut across everything. However, looking at the types of IP, each type of IP has its own advantage and disadvantages. And that is the reason why you have to know the exact type of IP that works for the type of industry that you have. So for example, we talk about trade secrets. Trade secret is that type of IP that you don't register. All you have to do about it is keep secret or keep quiet, make it secret or keep quiet. Or if you want to share the idea, you are advised to use a confidentiality agreement for a non-compete clause. Now, in a case whereby someone go ahead to reverse engineer your trade secret without getting the secret from somebody else, and the person decided to now reverse engineer and now patent what they reverse engineer, which is your own trade secret. Patenting that trade secret can keep you out of the market because somebody has a patent protection over it, of which trade secret does not have a way you can actually register it. So most times you have to look at the one that is actually profitable and work for your own industry. On the brighter side, look at trade secrets. Coca-Cola has been using trade secrets for 100 plus years and they are still in the market. Let's assume Coca-Cola initially patented their recipe. It means they would have had just 20 years to monopolize the market. And the other 80 years plus, what would they be doing? We don't even know what happened to Coca-Cola now, if they actually opted for the option of patent. So each of these type of IP has its own disadvantage and advantage. We have to look at the greater advantage they're going to have. Let's take trademark. Trademark has its advantage, but the disadvantage comes in use. When you don't use your trademark, you risk revocation of that trademark. So when you don't use your trademark can be revoked. So you have to use it and you have to maintain it. If you don't use it, you don't renew it, somebody else can actually take you out of the market if your trademark has been revoked. So you have to know all of copyright also. Copyright, we say, it protects the expression of idea and not idea in itself. But the truth is, yes, I have a copyright. I've expressed this idea maybe in a format. Somebody now goes ahead to express the idea in a B format. But before I get to B, I still have to go through A, right? So now the person have taken somebody's idea, but now have an original idea added to it. So you always have that issue of copyright that, oh, this person work as an element of my own work. But the question now is the substantive aspect of the work that was introduced into the new work. So each of these IP, like I said, have advantage and disadvantage, but look at it holistically and go with the best one that suits your industry. Thank you.
Thank you very much, Ms. Shukurat, for that answer. I'm grateful. We're gradually coming to the end of this session, and I'm grateful to all our mentors who made this possible. Highly reputed veterans of the IP space. They took their time to answer all our questions. So I'm still as excited as I was at the start of this program. It has been jaw-dropping, mind-blowing, enlightening, impactful, everything good. And I'm happy I'm the moderator of this session. So once again, I just checking the chat to be sure that we answered all the questions. Yes, we did. So thank you, Ms. Onyekachi, for answering all questions.
Sorry, if it's okay by you, there's a question somebody put on the chat. Is it possible to patent and trademark a product? I think I should speak to it. Yeah, I'd mentioned before that you can have a particular product cut across all forms or genres of intellectual property. Now, what happens, I think where the confusion based on this question may be coming from what the person has in mind, is perhaps what happens when a patent expires if it's a product that has both patent and trademark. Now, this is it. When the patent expires, it is the technology, it's the patent itself that expires, but the trademark continues to subsist, which means the name of maybe paracetamol, for instance, continues to subsist. However, Panadol has entered the market, para whatever else has also joined. Do you understand what I'm saying now? So those are now generics of the first one, which is perhaps paracetamol, if you get what I'm saying. So every other person joins me to use that my technology or to also produce that my drugs. Now they are now called generic drugs. But I still hold entitlement to my brand name, which is paracetamol, for instance. Nobody can come and say they're doing paracetamol. At best, they can have maybe Panadol and something else that is close to it, derived from my own paracetamol. So perhaps that's what the person is talking about here. Thank you.
Okay, thank you. I was in the middle of thanking you, Ms. Onyekachi, for bringing out your time, for answering every question with so much detail and assertiveness, and Mrs. Shukura Tamosa for approaching every question from a different dimension, from a new perspective. It's an eye opener, even for an IP enthusiast. And I wish to commend all our mentees, everyone that took out their time to attend this session and put in the effort, including preparing the slides and presenting, for putting in a good work, making the efforts. I hope you do remember to preach the gospel of Jiipcc, to tell your friends about this, so much thing, all the good things we've learned here, and so much knowledge that cut across on this platform. Hussein, do we have another thing on the agenda? Hussein? Oh, I think he left us. In the absence of any other thing, we would come to Miss Juliana. Miss Juliana, are you there? In the absence of any other thing, I guess we'll have to call it a day. Thank you once again, everyone, for coming to this session. And we've come to the end of it.